Hello, friends. We have Mr. Achille Forler with us here today, who's a permanent advisor to the board at IPRS and has been into the publishing space since the longest time. He's been the managing director at Universal Music Publishing, and it's an honor to have Achille here with us today. So, Achille, we complete 9 years since the Copyright Amendment Act of 2012 came into effect. You've been an active, pioneer in the whole music publishing space in India. So, what are your thoughts on this day to day? Do you see the amendment has achieved its objective with which it had come into place?
Well, the amendment, you have to put them in context. The context was the 1977 unfortunate Supreme Court judgment, which in my opinion, and I am not alone, is really a low point. It's not a bright day of the Supreme Court of India, which has practically denied the rights of authors, composers, unless they are capable of negotiating a contract to the contrary. To the contrary of what? To the contrary, the fact that the court said that the film producer is the first owner. How can a film producer be the first owner of a song when he's not writing the lyrics and he's not composing the music? All right. That decision was taken in a context where the Copyright Act itself was not clear about the separation of rights, because it used the word soundtrack for a film. A film consists of moving image and soundtrack. Now, what is a soundtrack? The point is that India was a signatory to, at that point, it was a signatory to the Berne Convention, which is very clear about what cinematograph film is. The Supreme Court should have referred to that. It was obligated to refer to that because international treaties take precedence over the national laws. So it didn't, and so you had up to 1977, you had some very good agreements. I have copies of about 61 agreements pre-1977, where the film producer says to the composer or to the lyricist, composer usually because it's the music director who was in charge of the project, you say that film producers don't own any rights globally, the rights are yours, and but to a separate letter, which I have copies also to the record label. At that time it was HMV, his master's voice, saying that you please pay 5%. They didn't say mechanical rights, but this was the decision, 1959 decision, that mechanical rights are 5%. So the film producer would say to the record label that you pay 5% to the composer and the author. So past 1977, the author composers became bonded laborers. Okay, nobody was able to retain his rights, and the rights were all bundled together. The film producer would sell the music rights. They were not separated into musical and literary works, that is publishing rights and phonographic rights. They were all bundled together. So in 95, between 1990 and 94, I was the audiovisual attaché in the French embassy. And my job was to report to Paris, to the French Ministry of Foreign Affairs, on radio, television, cinema, and music. So I did, in 93, I did a study of the Indian music industry and to see how France could connect with the Indian music industry, and because I did that study because a friend of mine in 1989, she had done a study on the distribution of Indian films in Western Francophone Africa. And it was her doctoral thesis. And the conclusion she came was that Indian films were more popular and generated more revenue than American films in Western Francophone Africa. Okay, so I did a study in '93 and say, you know, here is something, maybe we could do business together, our two countries. And that is when I realized that, you know, everything was bundled, music rights, publishing rights were not exploited separately. They were not registered in the French Copyright Society, SACEM, in 1993. When I went there, they had the equivalent of about $200,000, which they had collected for the use of Indian music over the years. And they didn't know whom to pay because only 11 Indian songs were registered in the database of the French Copyright Society. So I thought, here is a potential business. So I resigned from the French Ministry of Foreign Affairs and started Deep Emotions Publishing, which was a pure play music publishing company. Now, when you're a music publisher, the only client you have is the lyricist and the composer. Now, if they don't have any right, you have no business. Okay? So to develop my business, I had to fight for the rights of the authors and composers. It was a selfish fight in a way. So because things were wrong, and I thought at that time already that you see, there are very few countries in the world who create cultural products that are consumed across the world. Now, India was one of them. I mean, who is watching Singaporean films? Who is watching music, listening to music from Kenya? Or, you see, these are all cultures who live among their own, but cultures that travel, where you go to Russia, where I had a friend in an Indian who was based in Lima in Peru. He had two theaters in Lima, Peru in the 90s showing only Hindi films. In Peru, in South America. Okay, and he was having a good business. So I thought that for India really to develop and become a global player, it has to adapt to the global rules. The way copyrights are managed, the way royalties are flowing, you have to take advantage of this because it's a system that has been built over a century and that is very strongly entrenched. And so you have to use that system to get your money out. And that is how I created Deep Emotions. But already at that time, and we come now to your point, which is about the amendments. There were amendments in 1994. And one of the amendments was the definition of cinematographic film. Now, the Copyright Act said that there are three classes of rights: the musical and lyrical works, the phonographic sound recordings, and the cinematograph film. Now, what is a cinematograph film? This is where the 1994 amendment was a sea change. It says that the cinematograph film is the moving image and the sound recording. It did not say and the musical and literary works. Right. Musical and literary works were kept out of the ambit of the definition of cinematograph film. That is why I created Deep Emotions, because I said there is an avenue for me. But then, you know, we got court decisions, the North, 1977. 94 has overturned 1977. And no court has wanted to realize that, to accept it.
Achille, don't you think that if the amendment would have been clearly worded, at whatever was pre-amendment of 2012 is still history, but the idea was to kind of rectify those issues and bring more clarity, which unfortunately may not have been the case. So don't you think that there could have been a possibility of wording it with more clarity so that there wouldn't have been scope for more interpretation and different parties reading it to their own benefit?
Well, here too, you have to take a step back. What is the Indian Copyright Act? What are its origins? Its origins are the UK Copyright Act of 1956, which it is now commonly admitted, among scholars, it's one of the worst pieces of legislation that has ever been made. Okay, it's one scholar even, I think, wrote it down in her book. So anyway, that was one. And it was an Anglo-Saxon approach to copyright, which is very different from what we call the continental approach of France, Germany, Italy, etc., which today the European Union approach. So it came out from that. Then you had the 1977 judgment. Then that 1977 judgment, I must tell you, hasn't gone down well, internationally, because you see, it's wrong. It was a wrong judgment. And I went to meet Mr. Justice Krishna Iyer in 2006. I went to meet him in Cochin. And I said, what happened? And he said, I and Jaswant Singh, who was the other judge who delivered the judgment, Jaswant Singh ji, he used to call me Guruji. And whenever we sat together, most of the time, I would deliver the judgment. And I checked, out of 119 judgments they delivered together, exactly 100 were delivered by Justice Krishna Iyer, only 19 by Justice Jaswant Singh. But Mr. Justice Krishna Iyer said, he was very much interested in this case, and he literally took it out of my hands. So this judgment there was pressure on the Indian representative whenever they went to WIPO, whenever there was international meetings. So you have to fix that. So in 1994, when there were the TRIPS agreements, and so the Indian Copyright Act was updated, and the proper changes were made in the act, which read just like any other act, I would say, in Europe or the US. But the industry didn't accept it, and the courts didn't follow. So you see, law is one thing, the context in which the law is applied, and the level of training, because IP is really a special beast. And within IP, there is a huge difference between patents and trademarks and between Copyright Act. Patents and trademarks, you have to get them registered, approved by a third party. Copyright, there is no third party. The very fact that you created, you put pen to paper, you're the owner. You are recognized as the owner, and you can defend it against the whole world. And so it's something, copyright is, in my view, is the highest, as far as legal matters are concerned, is the highest achievements of the human mind. The fact that out of thin air, you can create a tune even without recording it. You can create a tune, and the fact that you can prove that you are the creator of this tune, you are considered the owner. You don't have to register. There is no other property under the sky that is like that. Any other property has to be registered with an authority. before you can claim ownership. Copyright is the only property in the world that you can claim ownership even without registering it. You see, just by the fact I am the creator. So I would say that Copyright Act, the way it is drafted, there are always improvements to be made. And I will come to that point in a little while. But more important is the training of the judges. Judges, and in the law schools, they have a proper IP training. That, IP is patents, trademarks, and copyright. But copyright is something totally different from trademarks and patents. It's an immaterial property. And the ownership is derived, it's sui generis by the creator himself. So in the Anglo-Saxon world, especially in the US, you see, the US became acceded to the Berne Convention in 1989. India in 1951. And even today in the US, if you don't register your work with the library, with the copyright registrar, you can go to court and claim ownership, but you cannot claim damages because you have not registered it. So you see, there is a clear difference between the Anglo-Saxon approach and the European approach. And so you have today, the Indian Copyright Act is a mix of the two. But the 2012 amendments, I would say, have pulled the Indian copyright further into what is called now, the European Union, the continental approach of copyright. Although it was already there in germs in 1994, when India was the first country in Asia to introduce the resale right for painters or photographers. Nobody asked the government to introduce resale right because you had a fantastic registrar of copyright at that time, a lady whose name unfortunately escapes me, I've forgotten, but I met her, very intelligent, and she said, no, we have to introduce this in our act. And her minister followed, the whole parliament followed and introduced the resale right. 1994, 27 years ago, has any painter claimed a resale right to this day? No. This clause in the Indian Copyright Act has never been activated. Never. Not because painters don't know it, because some of the painters have known it and I have informed them. But so what I mean is, you see, text, the law itself is one thing, but context is something different. This is what you have to take into account. When the industry doesn't want, when the authors or the painters or whoever, the creators are uneducated, are in a situation of inferiority, it's very difficult. You can have the best law in the world, but the practice will be totally the contrary.
So, for example, like simple things, say when the royalty provisions were introduced in Section 18, for example, had it been clearly defined as to who is supposed to pay, when will it be payable, in clear terms, do you think that would have avoided a bit of the confusion which is happening?
No, I don't know. You're a lawyer, so you know more than me, but I don't know of any Copyright Act that says who has to pay what. It doesn't exist. It says what are the rights. It defines the rights. At times, like here, it defines the percentage. It says equitable. That means 50-50. Equitable remuneration. That's it. That's enough. What more do you want? But, and to conclude on this question of yours, Anushree, Look, what was the income of IPRS when we took over in 2017? The act was in 2012. Okay, so it took 5 years just to claw back and, to come back into the position where the author, composers, and real publishers are in running IPRS. The income was 35 crores. Today, despite COVID, it's 165 crores. And potentially, it's if you have today the per capita income on music in India is lower than sub-Saharan countries per capita, okay? Lower than sub-Saharan countries. If we were, I calculated it, if the income from music would be at par with sub-Saharan countries, we would be at around 800 crores IPRS. If it were at the Asia medium, Asia, we would be at 2,400 crores. So you see, the problem is not with the Copyright Act, the problem is with the people who don't pay. There are broadcasters who broadcast radio, they don't pay. TV broadcasters who broadcast, they don't pay. Streaming services, well-known streaming services who don't pay. Spotify pays, Apple pays, Amazon pays, Hangama pays, but there are some other big guys who don't pay. Now, that's not the fault of the Copyright Act. And this is money. People need money to live. If they cannot make a living by composing song or by writing poetry or by writing lyrics, they'll take a job in a bank or do something else. And so you have, great talent who is lost to the industry. And when I appeared before the Joint Parliamentary Committee in 2011 for the amendments, I said one thing. I said to the members who were there, look, economics is one thing. There is an economic aspect to copyrights. But there is another aspect that you have to take into account. So let me tell you a story. One day, a friend of mine here where I am living right now, I'm on vacations in France, 27 kilometers from here, there is a professor. He is one of the leading neuro surgeons in the world. So many years ago, one day I asked him, and I said, hey, according to your science, what is a normal man? He said, look, Achille, there are two answers. One is going to take many days, but in a nutshell, a normal man is someone who knows where he comes from, who can tell who knows that one day he will die, and who can tell his story. Now, copyright is the ability of telling a story, whether it is in a song, in a poem, in a book, in a painting, in a movie, in a TV serials. It is the ability to tell the story of the people whom you represent. Now, if the law makes it such that you cannot make a living, that in your country, like I know many countries, when you go to the movie theater, you cannot see the movies made by your own filmmakers. You see the movies made in Hollywood or elsewhere. When you go in a bookshop, you only buy books written by foreigners. When you listen to the radio, you only hear foreign songs. Such a country, according to my friend, would become abnormal because they have no self-expression. They have no identity anymore. You would be like Singapore. You don't know who you are. You're just business. So the Copyright Act is the leverage that you give to the creators and all those who invest in the creative industries, the publishers, the record labels, the film producers, the television producers, to help them make an industry where people can make a living telling the stories. What would be India without, without Tagore, without Gandhi, without some Hussein, without, where you only look at the paintings of Rothko or of Picasso or others? What country would it be? It would be an abnormal country. So the Copyright Act is there to help somehow regulate that industry. To address one more question, Anushree, since there is still a kind of controversy about the valuation of what is more valuable, whether it is a pop song, a film song, or whether it is the background music or whatever. So I have been asked, what my opinion is, and because if you look around the world, some countries, they say, no, music is music, all music is equal value, okay? You have some countries that say, no, songs are higher value than background music. And so when I was asked, what do you think? I say, look, every country takes a decision based on its interests. Okay. Now, let us look at India. Does India is one of the largest film producing countries in the world, maybe the biggest. Does it have a background music industry? No, because background music industry generates what we call library music. There is today not a single library music available in India. I represent today around almost 300,000 compositions, library music, of which about 1,200 is Indian pieces. Out of these 1,200, there is not a single Indian composer. All this Indian music is composed by foreigners. People who were disciples of Ali Akbar Khan Saab in California, or Ravi Shankar Ji, or others, and who do very, very good, very, very interesting, or who make some Indian elements with electronic elements. But the point is not a single Indian composer. Okay, so today, if you look at the situation in India, say, well, background music is a stepchild. It's, it's an afterthought. People just, it's not considered. But the point is, background music is an art. Great background composers have not written great songs. I don't know of a great song of John Williams or Ennio Morricone. Okay, it's an art. Now, if you want to develop that art, if you say, no, I want that my country should have a background music industry. It should there should be people, publishers, record labels who create background production music libraries. If you take this decision, you say, all right, then music is music. But if you feel that there is no point, this is never going to happen, and so then make a difference. Say, okay, pop music is worth this much and background music is worth this much less. So the point is, it's a policy decision. It's not what is right or wrong. It's what policy do you want to implement. So, I think to sum up, I would say in the last 4 years, there has been a huge shift in the music industry, things have become more professional, more the publishing is becoming more and more separate from sound recording, though the same entity may exploit it. But there is an understanding that, everything begins with the song. Without song, there is no music industry. So if the authors and composers are just laborers, you see, there is no, everybody says that the 60s and 70s were the golden years of Indian film music. Nobody has asked the question, why did that stop at the end of the 70s? Why has film music has become such trash? Maybe something happened in 1977 that has triggered that. Because if you pay peanuts, you cannot expect huge hits. People spending, hits don't fall from heaven. It's an art, a craft, your whole life you have to develop, and moreover, in the creative industries, what people don't recognize is that there are ups and downs. You see, everybody, even Mr. A.R. Rahman has his ups and his downs. We all have. And when you're down, because you're shifting, because inside something is happening, you're moving to another plane, but it doesn't happen overnight, and you go through a crisis or you go through a questioning, you question what the work that you have done, and you feel that you should not repeat and you want to create something new. This takes time. It's not a matter of days or weeks. It can be a matter of several years. Now, in these several years, that person will not create great music. He will create average music. But he should be fed by the hits he has created earlier. So what I really regret is that there is very little, there is zero, in fact, there is zero research in India on artistic creativity, on the economy of the artistic creativity, of how the artist is not like somebody who, a day trader in a firm or on the stock exchange or an employee. It's something totally. He's a gig worker. He goes from gig to gig, from film to film. He's not an employee. Contrary to what 1977 Supreme Court said, he's not an employee. Where is he an employee? He has no benefit as an employee. He's a gig worker. So gig work, the gig economy, you see here we have COVID in France, just like in other countries. But the artists have been paid by the government all through. They have a basic social security. They have a basic retirement system. You see, the French society SACEM, which is the equivalent of IPRS, has its own retirement system. When you reach 65, you get your provident fund. They have their own provident fund. But to create all this, you need a proper, psychological, a whole understanding. And for that, you need people who do research on the gig economy, on what it is to be a painter in India, what it is to be a writer, how do you live, what can be improved, if you are writing a novel, for example, it takes you 10 years to write a novel, and then this novel is a super hit. Well, in the first year itself, when it is a super hit, the income tax in India will tax you as if you are a rich person. But what about the 10 years where you had no income? While in many Western countries, and especially in Europe, it is tapered over several years, depending on your last release. You see, but for this does not fall from heaven. It's not that something you have to copy from abroad. You need local people who do research And then there's the research, which is validated by the university. Then this research is given to the politicians, to the lawmakers, and say, look, this is the situation. You have to do this type of laws. They exist already in these and these countries. But this is why you have to do that. And not you have to make these laws because they exist somewhere else. So that I really appeal to lawyers, to young lawyers, I think, and academics. There is a huge field of research that is totally neglected. And unless some people do this research, the Indian entertainment industry will not benefit from that.
You're absolutely right. So, Achille, I mean, just to conclude, like, what do you think should be the way forward? Just your last concluding remarks on it.
Look, I had a high hope when the government decided to have, special IP courts. But then, good ideas often get get messed up by some big egos and whatever. So anyway, that the thing is, really, we need a good judiciary that we don't, when we go to court, it should not be a Russian roulette. That rules should be clear, and if somebody is not is breaking those rules, we should be clear. We should be confident. I get to court and I'll get the redress. Today, I'm not confident. I'm not at all confident to go to court. Sometimes I say, oh, I'll write this off as a loss, but let me not fight in court because it's so uncertain. So the courts are overworked, the judiciary is overworked. As I said, judiciary is also not trained in these matters. You have some bright people like Justice Gautam Patel, or you really love to read their judgments. I mean, the clarity of thought, and but they are, they are exceptions. They are not the rule. So the real solution, I think, is what is happening now. Is that, you see, T-Series has joined the IPRS. We are trying to make things work. There are egos, there are, some people like or don't like you, or that's okay. But in the end, we all pull together in the same direction. As you can see, the income of the music industry is increasing. That nobody can deny. And these are the facts. So we should stick to those facts. If it is increasing, it is because we are doing something right. You can always theorize, this can be better, and if we change this. No. If you want to change the Copyright Act, are you sure of what is going to come out? That's the first question you have to ask yourself. In 2010, we were sure of what was going to come out. We were damn sure. Why? Because the opposition was also agreeing. Mr. Jaitley was agreeing. And you had somebody reasonable, a distinguished person, intelligent, with whom you could talk sense. Do we have this today? Maybe, I don't know. But if you want to change the Copyright Act, you better make sure that you have all these. Otherwise, don't, because in the end, somebody is going to pull out the rabbit out of the hat, and you will lose whatever you have gained in your previous amendments. That is my position. So I have no problem with the act. Maybe, of course, you can always improve, but I have no problem. I have a problem with the judgments. I have the problem with the fact that users are not paying, big users. Not the school kid who is downloading. He's not my problem. My problem are the big corporates who don't pay, or who underpay, who twist your arms to pay. Instead of 100, they want to pay you 2. what negotiation can you have when it's such a difference when you say 100 and the other guy says no 2? There's no middle ground you can find, because they are unreasonable, because they think they have political pull or whatever they imagine, or because simply we can fight till the cows come home. We'll see you in 20 years. You take our terms, otherwise. One thing we have to recognize is that the foreign players are paying, and are paying fairly. So the Indian players now should start paying too. So somebody has to shame them. Somebody has to shame these guys. This is my problem. The industry should really speak up. Don't be shy. They owe you this money. They are using our content. They are using your content. They have to pay up. They cannot get away with this. They may have newspapers and TV channels. Who cares? There are social networks. That's it for me.
Thank you, Achille, for your time and your valuable comments. I hope all your messages should create some positive impact, and we should be able to work towards a better future.